Hi, Richard.
Hello, Lizzie. How are you?
Hello. I'm very well, thank you. The sun is shining, and I'm looking forward to talking a bit more about adverse possession. So we did a course for our local authority audience on adverse possession a few weeks ago, and there was a massive amount of questions which we weren't able to cover in the time that we had. So we're going to record this now, which is just going to cover some of the questions we didn't get to, as many as we can. So should we make a start?
Hmm.
So the first question I have is, what if it gets sold?
The question is really what gets sold, yeah, sort of a car or whatever. Um, if the land of the paper owner, if you like, gets sold, it's just I don't know if it means that, but then well, basically, before the adverse possession claim has been successful, and if the title's registered, it can be an overriding interest under Schedule 3, Paragraph 2 of the 2002 Land Registration Act, but only if you're in actual occupation of the land. And it's from a reasonable inspection that could be seen. So, if it seems that the fence is in, one particular place and there's a clear fence, then it'll bind a purchaser, the paper title owner's purchaser, if the land you're claiming the adverse possession on gets sold, well, it's a complicated thing. But if there's no gap in the sort of the occupation, if the possession, I should say, of both, the new person kind of moves in immediately or with a very little gap, then they can continue the amount to the claim, if you like.
Thank you. Next question. Does it matter if the highway is not owned by the local authority, but it's just adopted?
Yeah, most highway won't be owned by the local authority, but if it's adopted, it's just it's the surface, the subsoil remains with whoever is the owner of the land, but it'll be if the local authority are responsible for the maintenance, it'll vest in the local authority, Section 263 of the Highways Act. So yeah, it doesn't matter basically.
If a bypass has made a highway redundant, but the highway authority has not disposed of the land, does the Crown on the application of Smith and Cambridgeshire County Council case from 2010 still apply?
Uh, Basically, I mean, there's a lot of exceptions to it, but it's the principle of, once a highway, always a highway. And if the highway is no longer being used, it's still a highway. There are exceptions, like if it falls off a cliff, then it's no longer a highway. There's various pieces of legislation, such as Sections 116 and 117 of the Highways Act of 1980, where you can apply to the council for a stopping notice on the basis that the highway is no longer necessary. If you want to develop it or something like that piece of land. Local authorities have got it. I should say the Highways Authority has got a discretion in relation to it, but if there's no positive steps taken, then it's still a highway. And the Smith case said you can claim adverse possession over the subsoil, but that's pretty pointless. It's still a highway on top. You can't claim adverse possession of the highway.
Next question. To prevent adverse possession, am I correct in saying if the landowner grants consent to the occupier, this stops the clock on the 12 years? Can this be verbal, written consent, or a permissive agreement? And if any of these, how often should consent be renewed?
Um, there's actually cases on easements on this, where prescriptive easements after 20 years. It can be verbal consent. I don't like the idea of permissive agreements, just permitting somebody to use the land. That's where the problems would arise. And you've got potential adverse possession. Obviously, it's a verbal, it's a matter of proving it, but it could, in theory, be verbal. It's best to be written, as long as it's not within the requisite periods, which for unregistered land is 12 years or 10, or 12 years for registered land. If the claim arose before October the 13th, 2003, but I'd want it in writing.
If an adjoining owner erects fences along an incorrect boundary, is the owner of the land entitled to take these down, or is the only remedy to go to court?
Well, it's you have to be pretty careful as to whether it's an incorrect boundary. There's something which I mentioned in the course and still surprises a lot of people. A case called Clapham and Naga on it, Court of Appeal case from late last year. Section 60 of the Land Registration Act 2002, there's a general boundaries rule. You can apply between the two of you, the people besides that will be either side of the boundary, could be more than two, to determine the boundary at the land registry. But if that hasn't happened, and the vast majority of occasions it hasn't, you can't be sure that where the filed plan says the boundary is the boundary. So I'd be careful about that for the first part. If you are absolutely certain, you could remove the fence, but if you damage the fence in the process, you'd be creating a criminal damage, and it would be best to go to court, especially for people like local authorities.
If the landowner is also occupying the land or part, does this mean there's no exclusive occupation and therefore no claim?
Well, it's adverse possession. It's not the same as occupation. It means something different. You've got to have a situation where the paper owner has either discontinued, possession of the land, or being dispossessed. Doesn't need to be physically removed from the land, but they've just stopped using that land. If they are still using that land, then it can't be an adverse possession claim. With a question of degree, there was a case I mentioned called Tower Hamlets and Barrett, where all they had in the land was some rods supporting some neighbouring land, and that wasn't sufficient, to stop an adverse possession claim.
Thank you. Next question. If the land is under a licence or tenancy to another party and someone else makes a claim, is this open to a claim?
Yeah, you can still claim, potentially. If it's unregistered land, you're claiming against your claim subject to the tenancy. It's a case called St Marylebone and Fairweather, which is in the notes. Otherwise, if it's registered, you could claim take free. It's a case called Spectrum Investments and Homes.
Thank you. Next question. If commercial advert signage is on council land without permission, is this signage enough to claim adverse possession on the land on which the signage sits?
Putting signage on the land is probably, it's always difficult to know in these things because they depend so much on the facts. But that is probably not enough to either intend to possess the land for adverse possession or factually possess the land. So I doubt it very much.
If you send the occupier an agreement and they don't sign or pay, is this the start of a possible claim?
Yeah, that's a nice one. Potentially, yeah. And again, it's different if the title is not registered or the claim arose in unregistered land prior to October the 13th, 2003. Because obviously it's more limited. If your claim arises since October 2003 and the title's registered, you're claiming against.
Next question. What about land surfacing, tarmacked and painted, but not land fenced off?
It could be if there's a good reason for not fencing. There's a case called Thorpe and Frank on it, Court of Appeal case from 2019 or 18. If there's good reasons not fencing, then you don't have to fence. And a good reason for not fencing is if you've tarmacked land intending you park your car there, if it's fenced on four sides, you probably can't get the car in. So, yeah, you might have problems on occasion, but things like tarmacking the land is showing a factual possession and intention to possess. Yeah, I told you that one, the land on Exmoor, didn't I? Where they refused the claim initially at the land registry because it wasn't fenced on four sides when the fourth side was a 200-foot cliff into the sea. But that's wrong because there's a good reason for not fencing. Fencing is very, very persuasive, but it's not essential.
If someone is in actual occupation and is threatening to make a claim for adverse possession but hasn't yet, what action can the legal owner take to recover possession?
Again, dependent on the situation. If they've already got the 12 years unregistered land, pre-2003 registered land, they can make a claim. If it's registered land, you can claim after 10 years adverse possession, but if it's defended, then there's three situations, one or more of three situations you're going to have to use. There was that case, it was only a couple of days, I think, or a day before the course, Brown and Ridley, which she's now done a podcast on, Supreme Court case, where originally the upper tribunal said it has to be the 10 years adverse possession before you make your claim, if you like. So in that kind of situation, if you've stopped adversely possessing the claim, the land sometime in the past, you couldn't make a claim. The Supreme Court reversed that decision, and all you have to do is show 10 years at some time in the past, and you might suddenly, spring into action and make your claim for adverse possession, which is not an easy thing to actually deal with. It's obviously a correct decision, the Supreme Court, but it makes life a little bit more difficult.
Thank you. Next question. When does the clock start ticking when one party sells to another?
Again, I'm not sure which parties are selling, the people who are claiming or the people who are resisting the claims. But if it's the people who are claiming adverse possession, then there's not a gap, or a meaningful gap, then you can continue with the claim. But there was a case called Vodafone and Potting Shed Bar and Gardens, makes you think, where the court said that the new occupier, if you like, has to have the same kind of rights in the land. So one's freehold, one's leasehold. You can't continue the claim. It's all about mobile phone masts.
Mm-hmm. Okay, next question. If land is unregistered with no apparent owner, can a leaseholder of an adjacent property claim adverse possession, or is that right reserved for the freeholder only?
No, they could claim. All land's got some owner, but they could claim. That's why a lot of the adverse possession claims are going to occur when you don't know the paper owner, unregistered landowner.
Mm-hmm. Could you go into a bit more detail about the general boundary rule referred to in the notes?
Yeah, it's mentioned previously that there was predecessors in the land registration rules before 2003, but it's Section 60 of the 2002 Land Registration Act. The land registry, unless you've jointly or mutually asked them to determine the boundaries, they don't guarantee that the plan constitutes the boundary, which lots of people forget. Lots of people in neighbour disputes forget that fact. They just, as in that Clapham and Naga case, they just move into the property, see that the fence should be the other side of this stream, decide to take action, spend 300 grand in the courts, and the fence is, the file plan is not necessarily correct. But tell you where the house is, but doesn't tell you where the boundaries are. There's some remarkable cases out there.
Mm-hmm. Okay, next one, also around unregistered land. What happens where the land registry has mistakenly registered part of unregistered land to a neighbour, despite the paper title showing this land within the other owner's land without any evidence of adverse possession? Should there be rectification of title and other correction?
Again, it's general boundaries rule. You can't definitely rely on the file plan. You're supposed to look at other things besides, and there's lots of cases on, extrinsic and intrinsic evidence. There was a case a few years back where the court tripped off to the site itself to check. So you can't guarantee the file plan is correct. And I think, so do bear that in mind. There's lots of potential issues there.
Next one, can you claim adverse possession on common land?
Yes, you can, and town and village green, but you'll be taken, if you like, subject to the rights in common and the fact it's, the rights of the locals to use the village green for their pastimes and sporting activities. So it might not be the best thing to do, but yes, you certainly can.
Thank you. Next question. What if a landowner with registered title knows that an individual is in factual possession and it is beyond 10 years? Is there a timetable they should take action to try and remedy, or is it too late? Is there any onus on the party in adverse possession to take any action?
Well, if it's 10 years, the claim arises post October 2003 and the title's registered, you're supposed to make an application for adverse possession, but the paper owner will be notified and has got 65 working days, 13 weeks to object. And if they do object, then you've got to show, the applicant's got to show specific grounds, including a reasonable mistake as to boundaries. So there's large numbers of occasions when the title's registered, huge numbers of occasions, you'll know there's a mistake, the boundary line is not where it should be. But quite frequently you don't. In that Brown and Ridley case, again, is significant because you only have to show 10 years reasonable mistake as to boundaries, any 10 years in the past, not the 10 years before you're making the claim. So much more than if you'd have asked me this a month ago. You can just sit on the application, read the podcast, listen to the podcast, and
You
read
can
it.
try reading it, but it won't be very fruitful. The next question, can an adverse possession claim be based on the occupancy of a previous owner, or must it start from the date of the current occupier took possession?
Again, you can have a series of owners. A lot of the cases involve previous owners, sort of starting the adverse possession, and then you kind of continue it. That Buckinghamshire County Council and Moran case, which is one of the more important of all, that actually happened. So yeah, although that Vodafone case suggests that you're going to have the same kind of title, and you've both got to be freeholders.
Okay. Does adverse possession also apply to easements and other such rights?
No, that's prescription is the way you kind of claim in easements through long use, which is 20 years. It's very complicated and quite, I'd say, historic, a lot of it, but it's 20 years, although the land issue, for the most part, don't accept anything but a claimed easement until 40 years, access and light being the exceptions. But no, that's prescription. It's something different.
Can a landowner protect their land by putting up a warning notice of some kind?
Not necessarily. I mean, again, you can put warning that, basically notices up to potentially prevent prescriptive rights. Because if you're using force, secrecy, or you're given permission, what you do if you want people to claim, you're happy people to walk across a path across your land, be it a public path or an easement, which is private, you put notices at the entrance points. You're here by permission. We can withdraw that permission at any time. But for adverse possession, it's not the same. A lot of the cases are like this. It doesn't matter that you realise it's not your land, and it doesn't matter that the paper owner, basically, that at some stage in the future, the paper owner will want to get rid of you. You can still claim adverse possession, as in the Buckinghamshire Moran case again, and also Pye and Graham, the biggest case of all in the notes.
So the last question, can two parties jointly bring a claim for adverse possession?
It's a difficult one. That some cases say yes, and some cases say no. There's cases, for instance, on corporate bodies. Can you claim adverse possession? And they basically, some of them say yes, you can if the corporate body remains static, but if it's got a kind of a membership that fluctuates rapidly, they probably can't. And there's cases that say family members can claim adverse possession. They're called Brazil and Morrison Pinder, or Pincher, that say that all the family members must be claiming, if you like, or not just one or two of them. So it's very much a question of degree.
Excellent. Well, I think that's all of them. Thanks very much, Richard.
My pleasure, Lizzie.